How soon could jury selection wrap up? It sounds like they've whittled it down pretty quickly to about 100 so far.
Well, good morning, Marnie. It's a pleasure to be with you. Once they take the 600 or 700 jurors and interrogate them all and find basically 100 or 150 that are acceptable to the court, to the prosecution, and to the defense, then they begin eliminating that 150. They begin eliminating them individually based on the gut instincts of the lawyers. If they have a reason for eliminating that person, they should have stated the reason already, and they wouldn't be in the group of 150. Sometimes the gut instinct has to do with the composition of the jury. You wouldn't want all people that think all alike, that are the same gender, that are the same race. You want a composition of the community in there. That process is relatively brief compared to the process of interrogating them. So taking 150 and picking 12 jurors and 4 alternates could be done in about an hour. So I think that the estimation of opening arguments after lunch today is a realistic one.
So how likely is it that the judge in this case would sequester this jury, given the high-profile nature of the case and the national attention that is being played out right now in this small South Carolina town?
There's another factor that the judge has to take into account, particularly since this is a small town and a small county. It's not New York City or Chicago, and that is the cost of sequestering. It's enormously expensive to put the jurors and the alternates up at a hotel, to feed them 3 meals a day, to guard them and protect them, and to drive them back and forth. So sometimes the court will say, the publicity is so rampant, it has been so extensive, that it's a waste of time to protect them from other future publicity. So let's not sequester them. Sometimes the court will say there are things that the lawyers are going to argue, like the one we're going to talk about in a moment, that jurors simply should not hear, so we have to sequester them. My prediction, what I would do if I were trying this case, even though it's expensive, I would sequester them. The state's entitled to a fair trial. The defendant is entitled to a fair trial. Neither should worry about the jurors being influenced by what they read in the newspapers or hear on television.
Yeah, well, this is one of the most complicated cases, the different layers and some of the outlying cases and investigations that it involves. And what you're talking about, and we heard the exchange between the attorneys a moment ago, is the 100 or so financial charges that have been levied against Alec Murdaugh. What will the judge be considering when deciding whether or not that is admissible and the jury can hear it?
All right, so South Carolina law, and by the way, this is the law in almost all states in the union, allow the government, the prosecutors, to introduce what's called prior bad acts, uncharged, but if they had been charged and proven, criminal acts engaged in by the defendant. This sort of tarnishes the defendant and makes the jury think this is a bad person anyway, so he probably did what he's accused of. My view is that prior bad acts is very dangerous and unfair to defendants. But in order for the government to persuade the court to allow the prior bad acts to come in, and in this case, the prior bad acts are almost 100 acts of financial wrongdoing, stealing money from his law firm, stealing money from relatives. He's been charged with 99 acts of theft. None has been tried, none has been proven. He's innocent until proven guilty. But the government will have to demonstrate a logical relationship, what lawyers call a nexus. Think of a neck, a connection between the prior bad acts and the crime that's being charged. Dick Arputian, who's the defense lawyer, probably the best defense lawyer in the state of South Carolina, is arguing there's no connection whatsoever between these prior bad acts, even if he did commit them, and the butchering of his wife and son, and therefore they should not come in. The government is arguing these prior bad acts are a reason that we can explain to the jury was his motivation. Either the wife and son knew about the thefts, or killing the wife and son would divert the government's attention from the thefts. I don't know which way this judge is going to go, but I think it'll be a fair trial if he keeps these prior bad acts out.